We are a vibrant and dynamic boutique legal practice located here in the beautiful town of Clonmel, County Tipperary. Founded by our senior partner, John M. Lynch, we have a strong expertise in areas of insolvency, family law, wills and probate, property services, medical negligence, personal injuries and litigation.
As a legal practice, we're at the cutting edge of technology. We became one of Ireland's first paperless legal firms as far back as 2006. We use voice recognition software to make our document production more efficient. We have recently introduced firm-wide workflows as a further step in enhancing our service delivery. We are more than happy to share our knowledge and legal know-how via our website, information packs, and our weekly radio programme on Tip FM each Tuesday at 10 a.m. As a firm, we all share a keen interest in the study of law. We have personnel with first-class honours degrees, honours master's degrees, and various specialist diplomas in all our areas of practice. We have built a strong team over the last number of years and continue to invest in that team for the benefit of our clients. We embrace challenge and are not afraid to take on the difficult cases that other firms may shy away from. We offer our service to local, national and international clients through the medium of modern technology and modern means of communication.
We are a forward-thinking law firm, committed to ongoing improvement. We continue to invest in the empowerment of our team, supporting learning by in-house team meetings, lectures, certificates and diploma courses. We are particularly interested in the direction that our modern world of social media is taking in the delivery of our services.
We strive for excellence in both our legal know-how and our service delivery, and our key focus as a professional practice is to deliver the best possible service to each individual client.
We have been giving reliable, quality legal advice to our clients for over 35 years and look forward to doing so for another 35 years.
What is medical negligence?
Medical negligence is an area of law which is rapidly expanding at the moment, and it basically happens when your healthcare professional or your healthcare provider offers you or provides you a standard of care which falls below the standard of care. That means the treatment they have given you is below the acceptable standard of care, or there has been perhaps an omission in such as delayed diagnosis in the standard of care which they have given to you. It applies not only to doctors or consultants, it applies across the whole medical arena. We have been involved in all types of medical negligence cases, such as women's health cases, that result birth injuries, such as cerebral palsy cases, obstetric cases, gynecology cases. Other examples would be orthopedic cases, eye injury cases, neurology cases. So it covers the whole medical arena.
Why should I make a will?
You should make a will to ensure that your estate is divided the way you want it divided, and to ensure that the parties that you want to benefit from your estate benefit.
Who should I appoint as my executor?
You should appoint someone that you trust as your executor, because they are the parties who carry out the terms of your will. You can appoint a beneficiary under your will if you wish, so you could appoint your spouse or one of your children. You should ensure that the person you appoint is capable of dealing with the role that you are setting out for them.
Can I appoint my solicitor as an executor?
You can appoint your solicitor as an executor, and the solicitor will proceed to deal with the estate as per the terms of your will. They will include a charging clause in your will that allows for them to charge the estate for acting as your executor.
What is the difference between custody, access and guardianship?
Okay, if we deal with guardianship first, guardianship is it's the right to be involved in all important decisions regarding a child's upbringing, such as education, religion, where they live, any of those big, huge decisions, a guardian has a right to be involved in those. A guardian must also sign off on a passport application. A mother, by virtue of giving birth, is an automatic guardian. Where parties are married, the father is an automatic guardian. The father also becomes a guardian if the parties subsequently marry or after the birth of a child. In an unmarried situation, a father is a guardian, an automatic guardian, if he has lived with the mother for a requisite period of time, some of which must be the post-birth of the child. Access then is where the parents are living separate and apart, and one party is perhaps the primary carer of the child and the other party is given access. Custody is, I suppose, essentially the person who has the actual physical custody of the child, but at the moment, I suppose there's more of a preference to use the word primary carer rather than custody.
What are the stages in a purchase transaction?
Okay, well, stage 1 is you sale agree the property. You pay your booking deposit to your auctioneer. At that point, the auctioneer instructs both solicitors, one for the vendor, one for the purchaser, and asks the vendor's solicitors to issue contracts to the purchaser's solicitors. At that point, you need to contact your lending institution and ask them to send your loan pack to your solicitor. Once your solicitor has your contracts and your loan pack, they arrange to meet with you, deal with any pre-contract queries that you have or pre-contract inquiries that they may have themselves from a title point of view, and also instruct a planning search at that point. We will also instruct the purchaser to carry out a building structural report of the property to ensure that there's no structural defects. Once the contracts and the loan documentation are signed, we send back your purchase contracts to the vendor solicitors with the balance of the 10% deposit. We also send your loan documentation into your lending institution if it is the case that you are borrowing. Once the contracts go back to the vendor solicitors, the vendors arrange to have their clients meet with them to sign the contracts. It's only when we get back one part contract that the matter is binding on both sides. At that stage, we arrange a closing date, which is normally about 2 weeks from the date that we receive the contracts, and we request your funds from your lending institution. On the day of completion, we receive all the closing documents from the vendor solicitors and we pay over the balance of the purchase monies that are due and the keys are released.
What are the key stages in a sales transaction?
Breaking a sale transaction down to its simplest, you decide to sell, you give your property to an auctioneer. At the same time, you let your solicitor know that you're selling the property so that any queries, investigations, planning searches, or any potential problems can be addressed at an early stage. That has the advantage that as soon as you get a buyer, you can then, as in your solicitor is then in a position to issue the contract. That's stage 1. The contract then must be signed by the other side. If you've done your homework, all of the questions will be answered at that stage. Contract comes back signed. You agree a closing date. And between the contract and the closing date, all of the various queries are addressed.
Do I lose my job if I take an action against my employer?
Many people are afraid of bringing a case against their employer because of an accident in the workplace, because they're afraid of losing their job. You cannot lose your job because you're protected under the unfair dismissal legislation. So simply because you bring a claim, you cannot be dismissed by your employer. It may of course lead to a difficult atmosphere in the workplace, but it's important to remember that you're entitled to be compensated by your injuries. And more often than not, it's not your employer who's paying out, but rather their insurance company. And that's the reason that they are paying insurance. So your co-employees should not be affected by you bringing a claim.
What happens if a person falls into a pothole or trips over a defect in a footpath?
Yeah, very interesting area of law. The term that's used, which is a very, very old, archaic type of term, it's a principle of law called misfeasance and nonfeasance. It comes from, in case you're interested, it comes from the Latin verb of facio, which is to do something. And basically, if a local authority does something and does it badly, then they're liable. If they don't do anything at all, they have no liability. So it's a very old principle of law, and effectively it means that if you fall into a pothole that literally just comes, and it comes in a lot of roads around the country, you, as a general rule, won't have a case against the local authority. But if, on the other hand, they're doing roadworks, for example, and they dig a hole, and you fall into that hole and they don't warn you about it, well, then you have a cause of action. So that, putting it at its simplest, those are the principles of law that are involved.
Are there time limits for me taking my case?
Yes, and it's very important to remember those time limits. There is a time period of 2 years within which to bring a case. That 2 years stops from the date of the accident or the date that you know that you have been injured. Those time limits are set out by what's called the Statute of Limitations, and that sets out the law for time periods. So if you think you have a case, it's important that you act now rather than postponing it.
How are costs in litigation dealt with?
The general rule is that they use the phrase costs follow the event. So as a general rule, if you take a case against somebody and you're successful in that case, then you'll get the cost, because the event is the case, you're successful in it, and then costs follow the event. So you get your costs. If you lose your case, well, in the event of your, no pun intended, but in the event of you losing your case, well, then you lose your costs. So you have to pay the other side's costs. And of course, not forgetting, you'll also have to pay your own costs. So that's the general rule when it comes to costs.
How do I know how much I'm going to get if I've had an accident?
Your general damages, so the money that you get for your pain and suffering, is based on medical evidence. So initially when we meet with you, when we meet with a client, we cannot advise you on the value of your case until we have a correct medical opinion. And based on that medical opinion, then we can look to what's called the Book of Quantum and advise you of the parameters of how much we feel either the Injuries Board or the court would award you.
Do I always have to go to court?
No, you don't always have to go to court. In fact, you're obliged, first of all, to go to the Personal Injuries Assessment Board, and that was set up to filter cases, simplify the litigation process, and to try and deal with cases pre-court. If your case is not finalised or concluded in the Personal Injuries Assessment Board, you are then given what's called an authorisation. You issue court proceedings, either in the Circuit Court or the High Court. But again, it's important to remember that the vast majority of cases are settled either throughout the court process or on the steps of court.
So how long will my case take?
Your case will take 1 year approximately for the Injuries Board. If your case exits the Injuries Board without being concluded, it will typically take about 2 years for a Circuit Court case to reach conclusion and 3 years for a High Court case to reach conclusion.
What happens when I become a bankrupt?
Basically, all of your assets are taken over by an official called the assignee in bankruptcy. And all of your liabilities are effectively written off. Your income is controlled by the assignee in bankruptcy. You're only allowed to earn a certain amount of money. And the balance of your income then is literally given to your creditors during the course of the bankruptcy. So you can have a bank account, but you must operate it in credit. You can have a job, but you're accountable for whatever excess income that you get. And you can't hold a directorship in a company. And it used to be that you couldn't be a local representative, but that's now been changed. And effectively you're registered as a bankrupt for a period of 1 year.